I would like to thank the OECD for putting together something specific to compliance. My name is Daniel Sokol. I'm a professor at the University of Florida, and I'm going to talk to you a bit about AI and compliance. So I think competition authorities spent quite a bit of time in trying to understand artificial intelligence. In a recent work with co-author Justin Johnson, we focused on creating mechanisms that would facilitate compliance with competition law with AI, which is, don't think about AI merely as a tool for potential collusion, rather think about it as a tool for compliance. So in some ways, there's nothing profound about this. So much of data analytics is doing what we've already done before, but we can do it in a more sophisticated and rigorous way. To do that, we need more data. We need better curation of the data to make sure that we are able to get the right kind of data and get rid of the noise that isn't necessary. And we do this in the area of compliance, and again, ways that we've done before. So how else have we used data before? For decades, all kinds of stores have had access to data about how much do certain companies charge for their product, and they come up with their own white label at a lower charge. And today we call this self-preferencing, but in fact, the IO literature and the IO marketing literature shows that with regards to, say, supermarkets, this is pro-competitive typically. What's the analog here to AI compliance? In fact, we've seen aspects of this before. We just, for the last 20 years, called it screens. But we can do better screening with AI-related tools, and there are a number of ways in which we can do that. So this is about really unleashing the power of data in ways that we can apply. So let's be clear, both what it is and what it isn't, right? It's not the data itself that matters. There's plenty, I say with a caveat. With regard to public data, it's not really the data itself that matters. What seems to matter here, it's the complementary assets, such as sophisticated algorithms, and frankly, better engineering, so to speak, better data analytics that can get us to the right kind of answers, which is basically, do we have situations of either express collusion that we could identify, oftentimes a little more difficult, or some kind of tacit illusion or tacit agreement, this in-between word where we may have some signaling. And how might we do that? For example, we might use textual analysis in our machine learning. We have an initial data set, say certain words that seem to be particularly problematic. We then create a training data set, maybe some of those same kinds of words from competition authority press releases, certain kinds of cases, or at least the complaints that we see in such cases. And we might look at public data, such as securities filings, analyst reports, or other forms of public data, say public bid data. And we might be able to train AI to basically find some kind of collusion. I say we. By this, I mean not just competition authorities, but rather private companies that frankly care upstream and downstream, someone colluding to basically extract the economic rents. So what else might we do? We might have private data. And that a lot of times comes from mergers. And in mergers, as part of the requests for information, competition authorities might get lots of industry level data, and they might uncover, if they have the right kind of algorithm, ways in which they're able to detect collusion. And this is wonderful for a number of reasons. Number one, they might not have detected it otherwise. Number two, we've spent the last 20, 25 years really focused on unilateral effects. Why? They're easier to measure, But in fact, maybe we should return a little bit more to coordinated effects, because if we believe that coordinated effects may be serious, we might be able to uncover through mergers all kinds of collusive activity, whether it's tacit collusion or tacit agreement, or maybe in fact express, that we might otherwise not have but for algorithms. And so that's something to think about. So how does this play into sort of a broader competition compliance policy, and how do we think about it? Number one, it suggests that if private companies are willing to spend the time and invest in resources for robust compliance, you give them compliance credit, right? We want to make it worthwhile. By the way, having compliance credit does not threaten leniency. We have a number of jurisdictions with very sophisticated compliance guidelines that show the value of compliance. Here, I'm thinking of Taiwan, Canada, the UK, Chile, Singapore, authorities from around the world that have done so, Italy. And these are the kinds of authorities that I think are role models. Number two, robust compliance really does matter. And frankly, a lot of the business community wants to help. One of the best innovations was the ICC's compliance guidelines that they created both for large companies and for SMEs. And so this provides value to help companies really shape their own compliance program. Third, it turns out AI-related compliance is used in many regulatory authorities. I'll just give you one example. The US Securities and Exchange Commission uses AI-related compliance to monitor for insider trading. And so much of the nature of where competition compliance has come from accounting fraud. We can borrow from insider trading and other forms of securities and shall we say broader business compliance. And that business compliance could be AI focusing on anti-bribery. It could be AI looking at contracts, as we have, let's say, with IP licensing or certain terms that we're looking for sort of irregularities. And this leads me to my final point for the OECD, which is that there's a very rich set of discussions happening for the OECD compliance group. And I'd like to see more interaction between the compliance unit at the OECD and the competition unit. The OECD has been doing tremendous work, and I salute it for the competition committee. And I'm so glad to have been a part of this presentation.